We continue with the motion hearing of July 5th, 2006. The court. All right, then moving back to the defense motion to exclude members of the Sheriff's Department from testifying and overseeing jurors. Mr. Strang, are you handling this one? Attorney Strang. I am, or trying to. There is conceptually two parts to this motion. One, supervision of jurors or contact with jurors, and two, exclusion as a witness from the state's case in chief. Let me address supervision of jurors first. We learned today that on November 5th, the Manitowoc County Sheriff's Department decided to turn over responsibility for the investigation to other departments and to play a background role. And then we learned that the Calumet County Sheriff, according to the policy of having someone from another department look over the shoulder, so to speak, of any Manitowoc County Sheriff's Department employee who's involved in the investigation. Really, what we're asking for here is a continuation of that decision by the Manitowoc County Sheriff's Department and, in a sense, that policy that the Calumet County Sheriff implemented. There is, a department that was concerned enough about a conflict of interest or the appearance of a conflict to take itself out of the investigative responsibility and turn it over to two other departments that then were concerned enough about potential conflict of interest or the appearance of a conflict that, they provided a chaperone or an accompanying officer from another department anytime a Manitowoc County Sheriff's Department employee was involved at the scene. Certainly, I think ought to be. I'm not sure why you would oppose, then, implementing that same thinking when you're not talking about an investigation and a scene and collection of evidence, but rather talking directly about contact with the fact finders in the case. And if we simply extend this recusal or sort of turning over of responsibility from the scene to the jury and the fact-finding process in this case, we would have law enforcement officers other than the Manitowoc County Sheriff's Department serve as bailiffs, move the jury to and fro, move the defendant to and fro if he were to remain in custody. I think it's really not much different. Indeed, the argument for it is more compelling when you are talking about dealing directly with jurors because they are the fact finders rather than just talking about the assembly of evidence or the processing of potential evidence at the scene. The fact is that in any trial, the court is left to rely on court officers, bailiffs, usually Sheriff's Department personnel in this state, but I will call them court officers here. You have to rely on them heavily. They are the point of contact with the jury at the beginning of the day, at the end of the day, lunch, if a jury is sequestered. These people are housed in the hotel with the jurors. They are transporting the jurors. They are supervising what jurors can see and who they can talk to. And there isn't anybody looking over their shoulder. There is no one from an independent law enforcement agency to look over their shoulder. Now, I don't have any question about the ability of the Manitowoc County Sheriff's Department to do that in the ordinary case, just as they would investigate the ordinary crime in Manitowoc County rather than recusing themselves because of concerns about a conflict or the appearance of one. But in that sense, this case was tabbed on November 5 by the Manitowoc County Sheriff, or more accurately by his undersheriff, as not the ordinary case, as requiring a different response. And that really ought to extend to contact here with the jury, particularly if we have got a sequestered jury. The trial obviously should be fair, and it also should appear to be fair to the public and to the defendant and everybody else who is interested in it. I think it's an unusual case. It's an unusual request, but it's pretty well matched to the situation in which we find ourselves, where the department itself decided that it ought not be the front line in the investigation and the collection of evidence. So, as to the first part, I guess to some degree I'm adopting the reasoning that we have already seen Sheriff Peterson describe to his undersheriff and seen Sheriff Poggle implement at the scene. As to the second part, excluding Manitowoc County Sheriff's Department witnesses from the case in chief, Mr. Fallon, who is a very good lawyer and a neat colleague, and I enjoy his company and his work, but he's very deftly turned this and redefined this as a defense request for suppression. It's not. Not looking to suppress any physical evidence. Not looking to suppress any testimony, actually. What I'm looking for, what I'm asking the court to do, is to exclude particular witnesses as a limited sanction, only from the state's case in chief, so the defense could call them, or the defense could open doors on cross-examination during the state's case in chief. It would permit, then, the state to call in members of the Manitowoc County Sheriff's Department in rebuttal. And if indeed Sheriff Poggle is right, and at least as of November 5, this policy of always having an independent law enforcement agency person accompanying any Manitowoc County law enforcement officer, if that indeed was complied with, was made practice, not just policy, then I don't know how the state even would be impeded in presenting its case in chief by the relief that I'm requesting. Because there always would be somebody from DCI, or somebody from the Calumet County Sheriff's Department, or someone from the State Patrol, or some other agency, to testify to what was happening when a Manitowoc County Sheriff's Department employee was present. It's a little hard to know why the state even would object to the exclusion, but they are. The state is. And this is really, I think, not akin to suppression, but something much closer to the kind of sanction a court might impose on a party in a civil case, when that party fails timely to disclose witnesses, fails timely to respond to interrogatories, or requests for production of documents. It's the sort of sanction that is used for a failure of timely disclosure or timely action in civil cases regularly, used occasionally, at least in criminal cases, for the same sort of disciplinary reason on lawyers who may be dilatory or not following the rules. And here the remedy is even more closely matched to the problem, in the sense that the Manitowoc County Sheriff, I think, conducted himself very poorly, to put it mildly, on Fox 11, made highly inappropriate and inflammatory comments directed by name at Stephen Avery. I went through some of them before. I didn't touch on, the sheriff dredging up and discussing on television prior criminal acts and convictions dating back more than 20 years. It's the kind of stuff he's been around long enough to know juries aren't supposed to hear and ordinarily don't hear. It's at least potentially inadmissible and highly prejudicial information. So, this wasn't one stray comment at issue here. And he is the man who leads the department. He is the man who sets the tone. He is the man who makes the directions. He's the principal, if you will, and the others under him in that department are agents. And so this, I think, is a remedy that's pretty well tailored to the problem as to exclusion of witnesses on the basis that I have sought. The court. Mr. Fallon, by the way, I have read your written arguments and I will read them again, so you don't have to be repetitive. Attorney Strang, that's a very kind way of saying that I'm long-winded. Attorney Fallon, thank you, Judge. I just want to make a couple of points. First and foremost, remedies should be connected to the wrong. And in this particular case, the defense seeks to exclude from participation in the administration of the jury selection process and court security the Manitowoc County Sheriff's Department without, in any way, shape, or form, connecting the comments of Sheriff Peterson to concerns that somehow members of his staff can't follow your instructions, can't follow the common sense and what is, in effect, a policy that, from even Sheriff Peterson's comments this morning, run itself. He's given no orders, no instructions, no information to his staff, per him, other than do what you guys usually do, make it safe, etc. In other words, follow the policies that we have. There is no connection between the comments and a concern that somehow members of his staff are going to contaminate the jury pool. That's outrageous. This is not a single shred of information that connects those two. If the defendant has concerns about security for himself or courtroom security and wants the Calumet County Sheriff's Department to continue, as it were, and take over all facets of this particular case, then we might as well have the trial in Calumet County. Are we going to bring the entire Calumet County Sheriff's Department here and let them set up camp across the courtyard here and tell the Manitowoc folks how to run the jail, how to walk the prisoner over, and don't talk to the jurors, don't say anything about the case, don't even talk about the weather? Do we need Sheriff Poggle to do that? Again, let's have the trial in Calumet County if we're going to rely on everything else Calumet County has to resolve. And in that regard, depending on what this court chooses to do relative to the motion to adjourn, change of venue, depending on how you resolve that issue, the change of venue may very well moot this issue out. With respect to exclusion and suppression, rather than trade compliments with counsel on Dept ability to craft an argument, I will simply make this observation. If you say that a witness can't testify, then it may very well make it difficult for information collected by that witness to present it in court. So if the witness can't testify, then perhaps some further pretrial motion practice and perhaps some testimony, not perhaps, definitely, some testimony at the trial will be affected. Perfectly example. Detective Remaker was the first law enforcement officer, I believe, on the scene to verify the location of Teresa Halbach's car on Mr. Avery's property. Now, that's obvious because he's here in Manitowoc County, whereas the folks in Calumet County have to get in their car and drive here. So it only stands to reason that the first person here is going to be someone from Manitowoc County. So if we're saying, for instance, and this is a for instance, Detective Remaker can't testify, then that certainly creates some issues regarding the circumstances, regarding the preservation of the evidence and the scene until the official takeover takes place. So in terms of deafness or clever, you can certainly make the argument that, well, we're not asking for the suppression of evidence, we're just asking for an exclusion of witness. Well, that may very well impact the nature and the presentation of the evidence. And finally, to say that it's not suppression is a rather interesting issue. For instance, if the statement of an accused in a case is suppressed for reasons of a Miranda violation, that testimony may still be heard, perhaps in rebuttal or in an impeachment form, should that given witness take the stand. But it's still referred to as suppression. It's not necessarily referred to as exclusion. So whether or not you characterize it as exclusion or suppression, I think it doesn't matter. The real connection is that the appropriate remedy. The real connection is that the appropriate remedy. In Hudson versus Michigan and State versus Ward clearly tell us it's not. And the reason it's not is because the harm, for example, the comments of Sheriff Peterson, are entirely unrelated to, not connected to, the evidence which is sought to be excluded. And if, for instance, we are not to be impeded, and this is not that big a deal, I can't imagine why the state is troubled, Your Honor. Then my question is, if it's not meant to impede us, then why bring it? It makes no sense. The remedy must be connected to the wrong, and in this case it's not. The court. Mr. Strang, anything else? Attorney Strang. Yeah, as he did on his brief, Mr. Fallon expresses a good deal of concern and distress with me that I have not connected Sheriff Peterson to the people under him in the department. And indeed, I'm not trying to impugn the gentleman sitting here, or anybody else in the department. I'm simply following Peterson's lead, and Poggle's. I mean, the court wouldn't know this, but in his deposition, Sheriff Peterson testified that he's the last remaining member of the Manitowoc County Sheriff's Department who was involved in the 1985 case against Stephen Avery. Last one, who was around in 1985. Most of the deputies, I imagine, in this department were in junior high school in 1985. None of the current Manitowoc County Sheriff's Department personnel were named as parties in the civil lawsuit that occasioned this concern about a conflict of interest. As far as I know, nobody had any specific concerns about that, Detective Remaker or Sergeant Jost or anybody else in the Sheriff's Department, and yet all of them, by the department, were taken out of lead responsibility for an investigation of crimes that occurred in Manitowoc County and ordinarily would be within their jurisdiction. So I'm just simply picking up on the same connection as a matter of agency law that the undersheriff and Sheriff Poggle themselves drew here. As I say, I don't know if there was any specific concern on their part about the reliability of or integrity of this or that specific deputy or sergeant or detective. But the concern about the conflict of interest, by its nature, pervades the organization, and that concern is at least as great when we're talking about direct contact with the people who will decide the facts, as opposed to simply direct contact with the items of evidence that ultimately may be introduced to assist a jury in finding the facts. So I can be flayed for the want of a connection, but Sheriff Peterson and Sheriff Poggle would fall under the same switch. The court. All right. Also on the agenda today is the state's preliminary motion in limine regarding the jury hearing evidence concerning the defendant's 1985 wrongful conviction. I will hear argument on that motion at this time. It's the state's motion. Who's going to argue that? Attorney Kratz.
Thank you, Judge. Judge, this is a straight relevance argument. Both 904.01, .02, and .03, if a balancing test is to be performed, relevancy, of course, being defined as having any tendency to make the existence of a fact of consequence more or less probable. The state argues that the defendant's wrongful conviction, or the fact that the defendant was convicted and spent some time in prison, has absolutely no relevance in this case, does not implicate any fact of consequence. In other words, it would not be offered to prove or disprove or assist the jury on any element of the offense or other matter of consequence, but simply would be, in the state's opinion, offered for an impermissible purpose. Sympathy is not something for a jury to consider. Feeling sorry for Mr. Avery that he spent time for a crime that he was later exonerated for is the exact kind of evidence that should not be allowed. I appreciate the response by the defense, suggesting bias on the part of investigating officers, but the state argues still that when compared with, or when balanced against, the risk of impermissible reasons, the whole discussion of the defendant being previously wrongfully convicted has no place in this trial. Importantly, Judge, I believe it's instructive to consider the other side of the coin, to consider why evidence of prior convictions are precluded. It's permissible for the state to inflame a jury to indicate that a defendant has previously been convicted of a crime, again, absent some permitted purpose under 904.04. But the fact that the defendant was previously convicted of a felony, we know is inadmissible. It conjures bias, and it conjures prejudice, and the state therefore argues that a prior exoneration would equally be impermissible. Lastly, Judge, when we talk about 904.04, we talk about other acts. We're talking about behaviors. We're not talking about prior convictions or prior exonerations or prior not guilty findings. We're talking about behaviors. And when relevant for intent or identification, motive, or other permissible reasons, we are talking about behavior. Prior exoneration does not mean that the defendant is more likely to be exonerated in this case or more likely to be not guilty of this particular offense, which is exactly what the defense would be offering this kind of evidence for. So the risk, the very high risk of unfair prejudice to one of the parties, which is the state, which this equally applies to, that is, the relevant standard equally applies to evidence offered on behalf of the state as well as the defense and should be applied in this case. We're asking that the court exclude that evidence. Thank you, Judge. The court. All right, Mr. Strang, Attorney Strang. Evidence of Mr. Avery's prior wrongful conviction and the ensuing lawsuit against Manitowoc County is what the state seeks to exclude, absolutely, as I understand the motion. Like any other evidence, if this is proper at all, as I have argued on brief that it is, there is conceitedly a role for the court under Section 904.03. How much do we get into the 1985 conviction? How much do you get into the 1983 lawsuit? Section 1983 lawsuit, from whom, what kind of details? All of this raises 904.03 questions. And the court has a good idea in chambers that I will act on, which is to file a motion in limine here ourselves as to what specific evidence do we wish to offer of the wrongful conviction and the prior lawsuit. But the absolute position just can't prevail here in the end. I have argued on brief, and I won't repeat here, the bias and the credibility value of this evidence, explaining why the Manitowoc County Sheriff's Department and other officers may have acted as they did. Explaining, if he becomes a witness, why Mr. Avery may have acted as he did, or helping the jury to understand and evaluate his credibility if he testifies at trial. I will stand on my brief on all of that. I do want to add here briefly, without repeating the arguments in the brief, that it's awfully hard for the state, fairly, to say we need to introduce evidence of what Mr. Avery said to 3 men in prison and the pictures he drew for them in prison, and we want to introduce evidence if we have Mr. Dassey testify that, gee, Steve Avery wanted to go back to prison because life on the outside was tough, and then not allow the defense at least some room to explain that he shouldn't have been in prison in the first place and spent 18 years trying to get himself out, saying he was innocent. At a bare minimum, that kind of context is necessary if the state is to offer the evidence that it has sought to offer and pursues. I agree with Mr. Kratz wholly that if the issue were sympathy for Mr. Avery, that's not a proper purpose for this. It happens to be not why we're offering it, but it's not a proper purpose simply to make a pitch for sympathy. The same, of course, would be true for Teresa Halbach's life history, which the state proposes to offer. Had that no purpose other than generating sympathy for her or her family, it would be improper, and indeed, that's why there's a pattern of jury instruction in this state,
in which this court, I'm confident, will instruct the jury that it is not to decide this case on the basis of bias or prejudice or sympathy for one party or for anyone for that matter. So that can be handled very well with the jury instruction. And just as Ms. Halbach's life history evidence invariably will present a 904.03 question for this court, how much is right? How much is too much? How much distracts or confuses or misleads or wastes time? I think the same is true of the wrongful conviction in the lawsuit. It's clearly a Section 904.03 issue. It should be addressed before trial, an absolute position by the state on this, particularly if it's offering other evidence informing the jury that Mr. Avery was in prison. It just goes too far, just as I think an absolute position by the defense that nothing about the life or history of Teresa Halbach can come in also would be mistaken and would go too far. So we're going to be into, it seems to me, a balancing area. And I will try to assist the court by filing a motion in limine here by July 14, talking about just exactly what we hope to get into, with whom, and how. The court. Question for Mr. Strang. With respect to the bias basis for getting the evidence in, what witness or witnesses of the state is the defense seeking to argue that the wrongful conviction and the attendant lawsuit would show bias on the witness's part? Attorney Strang. Anyone from the Manitowoc County Sheriff's Department. Now, in practice, in this trial, that's likely to turn out to be, I can't rank order these, but it's likely to turn out to be Detective Remaker. It's likely to be Lieutenant Link, Sergeant Colburn, anybody. Those are likely to be the main players. But when you work for a department or a firm or a company and you are getting sued for $36 million, your department is, and it's been an embarrassment, it's been public, somebody who shouldn't have been in prison was, I think that's likely to affect the morale, the bias. May be subconscious, but it really is likely to have a human effect on the people in the department. There can't have been warm feelings about Stephen Avery, or even neutral feelings about Stephen Avery, at the time this was going on. The court. Mr. Kratz, if the state allowed, or if the court allowed into evidence, any of the statements that would, by their nature, suggest that Mr. Avery was in prison at the time, wouldn't it be fair to let the jury know that he was not there serving a sentence for a crime that he is still convicted of? Attorney Kratz. I'm not sure that we would have to include where the statements were made or under what context. And I appreciate Mr. Strang's concern in that regard. And I may need to fashion an explanation as to how or in what context those statements may have been made, but I'm sure it could be done. I don't think that we have to include that these were statements that were made by Mr. Avery in prison. Let's not forget that the first 6 years, Mr. Avery was not there for some impermissible reason. The court. I understand that, but I think it is significant that at the time the statements were made, he wasn't supposed to be there. What's the state's response to the bias argument? As I understand, and I don't have, obviously, first-hand familiarity with the lawsuit, but the argument is that not only was the defendant cleared of the crime, but another police agency had provided the sheriff's department with information about the person who was really responsible. And the sheriff, on the stand here today, indicates he still doesn't really accept the fact that the defendant wasn't guilty of that offense. Does not show bias on the part of at least the sheriff himself, if not other members of the department. Attorney Kratz. Here's where I agree with the defense, that the balancing test under 904.03 has to come into play, but then this court has to decide whether or not it's relevant.
This court has to decide whether it's reasonable that police officers would try to set up Mr. Avery because of a civil lawsuit, whether they would pick some unsuspecting woman and kill her, if in fact that's going to be the argument, that bias went to that extent and dispose of her body because of this lawsuit. So it's in those kinds of suggestions of bias and how far they extended, whether or not this is for a permissible bias reason or whether or not it goes beyond that into something that we're talking more about sympathy or an impermissible reason rather than appropriate bias. Attorney Strang: I can say a couple things. First of all, the court doesn't sit to decide the reasonableness of the inference of bias, the jury does. That said, I can't imagine that anybody at this table is going to argue that someone in law enforcement murdered Teresa Halbach. I just don't expect that to be an argument. Will there be questions about the fairness and integrity of the investigation and how they came to focus on Stephen Avery? You bet. Will there be questions about the reliability of physical evidence? Yes. Will there be questions about the reliability of testimony? Yes. The court: all right, the next motion I have was the motion relating to the state's motion to offer, evidence concerning the victim's life history. I know I got a letter from Mr. Buting, I think yesterday or the day, I guess it was technically the 3rd, indicating that it was premature to address this motion until the information proposed was offered with a little more specificity. And I got as far as getting your pleading on my bench here, Mr. Kratz. I'm not sure what... Attorney Kratz: Judge, that pleading has to do with statements of Ms. Halbach. The court: oh. Attorney Kratz: that's number 7. The court: all right. Attorney Kratz: that's to be addressed on the 19th. The court: I'm not sure that I can address your request in the abstract without knowing exactly what it is. I'm certain that to put anything into context, some background information is always appropriate. But I think, as Mr. Buting points out, there could be a lot more evidence that would be appropriate at the time of sentencing that wouldn't necessarily get in at the trial. So I'm not sure that the court can issue any meaningful decision on the request as is currently framed. Attorney Kratz: if I may, Judge, I don't know that Mr. Buting and I are very far apart. We understand that in a homicide case, when taking of a life is at issue, some aspects of the victim's life becomes relevant. Her contacts with Avery, her employment, her family relationships, those things that intersect, if you will, her life with that of Mr. Avery. That being done, though, at least some photographs of the victims, or some evidence of those characteristics, or part of Teresa's life that, again, puts her in contact with Mr. Avery, will be relevant. State has no intent to overstep its authority or to offer any of this evidence for sympathy or other reasons, just those that are relevant. It's my, perhaps, clumsy attempt to obtain pretrial rulings when I can, so that we don't have to stop the trial or have those discussions in the middle. I intend, Judge, and I think perhaps this is the best addressed by sharing it with the defense. If there are going to be photographs, if there are going to be kinds of evidence that, again, are relevant as to Ms. Halbach, and especially as they intersect with Mr. Avery, and as I previously mentioned, I don't think that Mr. Buting and I, when I read his response, are very far apart at all. The court: all right, Mr. Buting. Attorney Buting: I guess I would just suggest that perhaps they do the same thing that we're doing or that the courts asked us to do, which is to file a motion in limine on how we would use the wrongful conviction. If the state wants to identify, certainly,
any way that Teresa's life intersected with Mr. Avery, I think is going to be fair game, just to set the context. I'm not sure about relationships with her family and all those kinds of things, but I think if the state wants to do that, they can file a motion and then, before trial, share his concern about all these things coming up in the middle of the trial. But I think a motion in limine before trial, where he can lay out the limits and the parameters of this kind of evidence, is the way to go. The court. All right, I'm going to trust Mr. Kratz to do that. I don't know that it's necessary in every case that the state provide the defense with a summary of background victim information, but given the length that the parties are anticipating for this trial and the fact that wherever we have a jury, they are going to be around, take a sizable chunk of time out of their lives, I think to the extent that we can resolve matters ahead of time, we should do so. There's another motion filed by the state regarding prior criminal convictions of the defendant, and it's my understanding that the parties were going to work together to resolve that. Attorney Kratz.
We will, Judge. We will reach a stipulation on that, and will attempt to reach stipulations on any witness, whether called by the state or the defense, prior to trial. If we have issues that the court needs to resolve, whether it's issues of remoteness or relevance, we will bring those to the court. But I'm quite confident, with the number of years of experience between all of us, we should come pretty close to coming up with correct numbers.
Attorney Strang. Right, this will probably get worked out. We can raise our hands if it doesn't. The court. Okay, I think that takes us to the motion for bail reduction. I believe everything else has been addressed, unless I've missed something. Attorney Kratz.
There was one issue of the Marinette detective, and we do recognize, Judge, with the court's previous ruling on the change of venue, that it's quite clear that a third hearing is to be set in this case. There was, as the court knows, an audio tape recording of Mr. Avery's interviews with the Marinette detective. We felt it fair to at least suggest to the court that that be provided before they have an opportunity to cross-examine the detective. And so we plan to do that. And anticipating, we will set a date before we leave here today. We suggest, at least the state suggests, that that entire motion then be dealt with on that third motion date that we are contemplating.
The court. Any objection? Attorney Buting. Nope, Judge. The court. So I will hear the bail motion today, and we'll set another hearing date then for the other motion. Attorney Strang. I'm sorry, do we have his schedule? Attorney Fallon. He's still here. Would it be possible? The court. We can set the date now. How about Thursday, August 3rd? What does that look like for the parties? Attorney Buting. Judge, that's the week I'm going to be out of town and out of state. Mr. Strang, I think, is gone the week before, but the week after that, perhaps? The court. Wednesday, August 9th? Attorney Fallon. That's fine with us? Attorney Buting. That's good. Attorney Strang. That's good. The court. All right. 9 o'clock on the 9th. Attorney Kratz.
And so that we're clear, Judge, that is at least the change of venue motion and the statement of the Marinette detective and perhaps whatever we don't accomplish on the 19th. Does that sound fair?
The court. Everybody agree with that? Attorney Buting. Change of venue in the sense of argument and decision, or the court? Well, let's see. I'm anticipating it would be a decision at that time because I'm going to get some written submissions from the parties, correct? Attorney Kratz.
That's fine.
The court. Between the written submissions and the media reports I'm going to have to review, I think that's fair. I don't believe any further argument or evidence is necessary, is it? Attorney Buting. Right. The court. Very well. Attorney Strang. On the change of venue, here are the 2 boxes. The court. Okay. Attorney Buting. Should we mark them? The court. The clerk will happily take them to the clerk's office when we're done today, I'm sure. Attorney Strang, I'll be happy to help. The court, maybe you can help her out. Attorney Strang, I can carry them physically. For the record, what I'm tendering her, 2 bank boxes to include thousands of pages of the photocopies I described earlier, and 24 DVDs of television clips concerning this investigation and the prosecution. The court, very well, all right. At this time, then, I will hear argument on the bail motion. Mr. Strang, will that be you or Mr. Buting? Attorney Buting, it's going to be me, Judge. Judge, we filed a motion for reconsideration of the bail, our motion to reduce bail, I believe, on June 2nd. June 1st is the date here that we signed it. I think it was filed in the court on June 2nd. This is our first chance to argue it. There have been some changes since that date in what we would have put in the motion or presented to the court. But when we last discussed bail, it was on March 17th, and it was in conjunction with the state's motion to amend the criminal complaint, adding additional counts against Mr. Avery based upon the statements, alleged reliable, credible statements of Mr. Dassey, the 16-year-old nephew. And we argued at that time, and provided whatever case law we could, that Mr. Dassey's statements were simply not reliable and shouldn't be admissible or considered to establish probable cause in the criminal complaint. And the court disagreed and found that they were reliable for that purpose. The state then objected to our motion to reduce bail, and in fact filed their own motion to increase the bail, based again upon solely the statements of a 16-year-old Brendan Dassey, which were set forth in lurid detail in the criminal complaint. And on that basis, the court found that because of those statements, and only those statements, Mr. Avery's bail should be increased from $500,000 to $750,000. Now, since that time, substantial evidence has disproved, certainly called into question, the reliability of that young man's statement that are in this complaint. As a matter of fact, the majority of the story of how Teresa Halbach supposedly lost her life at the hands of these 2 individuals has been proven to be incorrect, either lies or guesswork made up by Mr. Dassey at the coaching of his interrogators, some of which were placed in our written motion. He claimed, for instance, that she was handcuffed to the bed when he saw her for the first occasion. The crime lab tested those handcuffs. Her DNA was not found on the handcuffs, but suggesting that they were not wiped off or wiped clean. Mr. Avery's was found on the handcuffs, as well as another individual, not Mr. Dassey, again suggesting that these handcuffs were not used, that she was not restrained by handcuffs as Dassey claimed. Because if she was, one would certainly expect the poor woman, struggling, would have left at least as much DNA as somebody else like Mr. Avery or the other unknown individual would have, just handling them. So that immediately called into question the credibility and reliability of Brendan Dassey's version of what happened. But then there were some other things that developed. His statement also claimed that they cut off 3 inches of her hair, I believe it was, and the crime lab ripped up all of the carpet from Mr. Avery's trailer, and they took all of the wood paneling off of the walls as well. They found no hair. He also claimed that she was brutally stabbed, her throat cut in a horrific description, pure fantasy of how that woman supposedly died at Mr. Avery's hands, in a manner that would have obviously left blood on the mattress soaked through the bedding. Even if the bedding had been disposed of, the mattress would have had evidence. Everybody was talking about it, even on the street. Well, where's the evidence of this? Wouldn't there be blood on the mattress? Well, sure enough, they took the mattress, and it's the same mattress, and there was not a speck of blood on it. And he also claimed that Mr. Avery then, after she had been brutally stabbed and bleeding all over the mattress, then carries her over his shoulder out into the garage obviously would have been dripping blood all the way. Again, not a speck of blood anywhere on the carpet or on the steps or anywhere leading out. And as a matter of fact, with all the tests that they've done of all the stuff in his trailer, not one speck of Teresa Halbach's blood or DNA has been found in Mr. Avery's trailer, directly contrary to what they claim in this complaint to be reliable, credible evidence, sufficient to have this court increase his bail. Now, recognizing that, the interrogators went back to Mr. Dassey on May 13th, I believe, and did another interview of him, once again, coaching, leading, trying to change his story to fit their theory of what happened in this case. And thank God for State versus Jarrell, because it's recorded for you to see, or anyone else to see, eventually in this case, or in his case. And the manner that they question him is, it would be laughable if it wasn't a real case with real people's lives at stake. He is fed information to change his story. Now, it turns out, according to this young man, that the whole story about him getting off the bus, finding a letter of Mr. Avery's, and going down and hearing this poor woman screaming was totally made up. He hears no screaming outside the trailer. He claims that he goes in the trailer and, yes, she's there. But again, the entire time he's there, she's never screaming, which is frankly rather preposterous. And he now, because he knows with his lawyer and what's been made public, that there's no DNA on the handcuffs. It's like, oh, I was wrong about that. It was rope. Her arms were bound by rope to the headboard. So they test the headboard and there's no rope fibers on it. They swab it specifically for that purpose. No evidence once again. And his interrogators press him about that and they say, well, was that a lie? And he says, yes. Did you cut her hair off? No, that was a lie. Why did you tell us these things? Where did you come up with these things? Just guessing is his response. Recognizing that there is no blood or DNA in his trailer, it is now obvious this young woman was not killed in his trailer. So the interrogators get him to try and move the location. Again, not accepting the possibility that Brendan Dassey's entire story is wrong. They just want to change it and somehow make it fit the physical evidence. And so now she is supposedly killed in the garage. And there's one piece of evidence that they have found, and in that in some way might support part of his story. Allegedly, there is a very small amount of her DNA that was found on a bullet somewhere in the garage, although it wasn't found until after March sometime when they researched the garage. But as we put in our written motion, it's a garage that is fairly accessible to many people, not just Mr. Avery. And, of course, it wasn't found until 5 months after Mr. Avery had been in custody, so many people had access to it during that period of time. But other than that, again, and they challenge him, frankly, it's pretty obvious. And frankly, I have a copy of it. I can offer it to the court. Introduce it if you would like to look at it. Listen to this. But you can tell that the interrogators don't even believe most of what he's saying until they get him to say what it was, what they want to hear, that they think might somehow fit the evidence. But they say, well, where's the blood? Well, where's the knife? They never found any knife. There was no evidence that there was ever any stabbing of this woman. He's got no explanation for it. And they say, well, one would think that there would be blood because, again, now the killing is supposedly in the garage. And it's not just a gunshot. In fact, originally it was 10 times that he shot her. Now he's changed it to 5. But there's still the stabbing that's going on. And with her now in the garage, there's no blood to support it. And they're relying now on, oh, well, they cleaned it up with bleach and gasoline and all that stuff. Well, in truth, there was bloodstains found, or there were bloodstains found on the floor of the garage, Mr. Avery's. The man works on cars in there for every day. He cuts himself repeatedly. His blood is found in numerous places, but not hers. If it's all cleaned up with bleach, why is his blood found anywhere? Again, it doesn't fit. In essence, he has now retracted almost everything. This dramatic press conference statement that children should not listen to this, it's so terrible to hear, was pure fantasy, unsupported by any other physical evidence, and now retracted by the guy who supposedly told it. I feel sorry for the Hallbachs, that they think all these horrible things happened to their daughter and sibling. Now we know that's not even true, but that's unfortunately the reality. I can go on and on. Did he punch her, or did Avery punch her in the mouth? Now, he's like, nope, he never hit her at all. Not only that, he now retracts any knowledge that he has that Mr. Avery ever had any sexual assault. He's still on his newest statement, newest I'm aware of, admits that he had sex with her, although the way he admits it is certainly suspect. But he says, no, I didn't see Avery have sex with her. No, he didn't tell me he had sex with her. So the whole sexual assault charge against Mr. Avery that's in this criminal complaint, and for which his bail went up, is now going to be out the window. In Mr. Avery's own bond hearing, the prosecution revealed, and by the way, I think the description of Sheriff Poggles, the purpose of these press conferences was to control the information that went out, is a very good description of what's been going on in this case, in the public's eye all along, which is the prosecution has controlled the evidence that the public hears and construed it in a way that makes it look like this guy should be the poster boy for the death penalty, when in fact everything that they construed is one-sided. It leaves out all kinds of other things. Looking at that press conference, you would have expected that young boy who was holding this in for months and just had to unburden himself with this terrible story that he had, experience that he had, was emotionally upset and came out with this whole long story when, in fact, there is not one iota of emotion expressed by the guy. He never cries. He's not upset at all. He's not coming out with any narrative. It's one sentence or one word responses to their questions the entire way, all the way through that first statement. And the second statement is more of the same. There is no emotion. If this kid had any involvement with it, he certainly hasn't described what happened or what his involvement really was, because there's no emotion connection or affect here. But back to the bond hearing, the prosecutor announced, oh, well, now we have new information that this was a planned murder and that they selected Teresa Hallbach several days earlier. And again, I suggest to the court, look at that statement. Brendan Dassey says nothing about any planning until they suggest it, as the only explanation they can come up with for why there isn't more evidence. And after he's badgered with this, he finally starts, well, yeah, I suppose. Again, guessing, answering their questions. But when they press him about, okay, what was the plan? There is no plan. There's no discussion about who is going to do what, how it's going to be carried out, no plan to have sex, no plan on why Teresa Hallbach. When they start pressing him on the obvious questions, he can't answer any of them because, again, it's just a fantasy. It's not the truth. And then when they ask him, well, why would Stephen Avery have planned this? Why would he have done this again? Again, there's long pauses in all these answers. And he comes up with, well, he wanted to go back to prison because he missed it. And even their own interrogator throws up his hands and says, he didn't say that, did he? Come on, start telling us the truth. And then there's a long sequence where they start badgering him about how he has got to help himself. And he is not being honest with them, on and on and on. So they don't even buy that story, yet they offer it in Mr. Dassey's own bond hearing, and probably would do so here too. So in short, the criminal complaint is no longer credible and that all of the evidence that they have done, all the testing that they have done so far, has disproved Mr. Dassey's credibility and his involvement, and therefore the involvement of Stephen Avery in the murder and any other offenses that go along with that of Teresa Halbach. What we're asking is the court to, therefore, reconsider the bond, to once again consider, first, reducing the bond back down to the $500,000 that was originally set before this Brendan Dassey fantasy was filed, and then to once again consider a property bond posted by Mr. Avery's family. He's shown no evidence of a risk of flight. He's fought for 18 years to get himself out of prison. He intends to. He's conducted himself in jail and in this courtroom with perfect decorum and showing no evidence of being a disruptive individual who's a risk of flight. Yes, he's facing serious charges with a great deal of prison time, but that's the purpose of monetary bail or property bond bail, to ensure that he will return. $500,000 is a lot. It's his parents' entire property, his brothers and sisters' entire property. He's not going to risk forfeiture of that by failing to reappear in court. So for those reasons, I would ask the court to reconsider and reduce the bail to what was originally asked on March 17th. Thank you. The court. All right, Mr. Kratz or Mr. Fallon, which one will be addressing? Attorney Kratz.
I will, Judge, and I must say, I'm surprised that somebody, we have given a lot of compliments around here. Somebody with Mr. Beating's reputation would come into this court and express to this court that he knows for certain, or that he has some personal opinion that this statement by Brendan Dassey is fantasy, or that it's made up, or that there are such inconsistencies in this statement that it should be disregarded. Mr. Beating doesn't know that. Mr. Beating can discuss inconsistency of Brendan's statements, but what Mr. Beating hasn't expressed to the court, at least what the state would argue, in a factual or proper manner, are the consistencies that Brendan did provide in his second statement. Brendan Dassey, in his second statement, which, by the way, was at the invitation of a defense attorney, after his statement was not rejected by Judge Fox, does include consistencies. The consistencies that it was he and Stephen Avery who killed Teresa Halbach, that it was Stephen Avery who stabbed Teresa Halbach, that it was Stephen Avery that shot Teresa Halbach, that it was the shooting that occurred in the garage, that it was he and Stephen Avery who mutilated the body of Teresa Halbach, hid her car, and thereafter tried to clean up or destroy evidence. All of that information was included in Brendan's second statement. What Mr. Beating did indicate in kind of an by-the-way manner was that there was a bullet now found in that man, Stephen Avery's garage, that had the victim, Teresa Halbach's DNA on it. That is not insignificant, Judge. That is additional evidence that this court did not have since the March 1st statement that was given, and should not be given such a short shrift. What Mr. Beating perhaps forgot to tell the court was that Mr. Avery's DNA was also found on the hood latch of the SUV of the victim since the first statement by Brendan Dassey. And because of Brendan Dassey's first statement that Stephen was fooling around with and opened up the hood of the victim's vehicle, the hood latch was swabbed and a full DNA profile match of Mr. Avery was in fact developed. That's been provided to the defense, and again, maybe Mr. Beating forgot to tell the court that. Mr. Beating and Mr. Strang also know that additional admissions have been made by this young man, admissions to family members that not only he was involved in the murder of Teresa Halbach, but very clearly that Stephen Avery was responsible for her death. The defense now also knows that the victim's PDA Palm Pilot was found with the cell phone and camera on the Avery property. So together with the inconsistencies that have been additional, not only consistent statements made, but additional physical evidence which has been developed. I also wish to alert the court or direct the court to my previous bond arguments. All of the previous evidence about the degree of violence, the prior record of this man, the ties or lack of ties to the community, flight risk, the penalties that he faces, and the gravity of the offense apply today equally as they did previously. I'm asking this court deny the motion for the reduction of bond. That's all I have, Judge. Thank you. The court. Mr. Buting, anything in rebuttal? Mr. Attorney Buting. No, Your Honor. The court. All right. The court, in addition to the oral argument today, before today, read the written argument in support of the motion. And I gather that, from what I know, there appear to be at least some inconsistencies in Mr. Dassey's version of events that was originally given to the police versus what he said recently. The significance of those inconsistencies is in dispute here today. We're only at the bail stage. The court is not in a position to weigh credibility of the parties or make determinations as to who's telling the truth and who isn't. That's the province of the jury. When the court last reviewed bail on March 17, I did consider the fact at that time that the state's case appeared to have been strengthened from what it had been earlier, to the extent that it was no longer based on purely circumstantial evidence, but that another person claiming to be an eyewitness and, in fact, a co-defendant had been identified and made statements incriminating himself along with Mr. Avery. While different statements that he's given since then may have some effect on the credibility of the version of events he gave, that's still the case. That is, there's still another person who's made incriminating statements identifying himself and Mr. Avery. The nature of those statements seems to be such that they are, at least not obviously, on their facts or on their face, designed to shift blame to someone else, because they are heavily incriminatory of himself, namely Mr. Dassey. I would also point out that it's not true that the court, at least the last hearing, only bases its decision on the statements of Mr. Dassey. Of at least equal significance was the fact that the defendant's financial situation had changed considerably. Specifically, it settled a lawsuit for $400,000. The facts, as they existed back on March 17th, are largely still present today, even if the defense may have some additional argument to discredit Mr. Dassey's version of the events. For the purpose of this bail hearing, I do not find that there's been any measurable change in circumstances. And so for the reasons that I gave on March 17, and as I have reiterated them today, the court is not going to modify bail. I will leave it at $750,000 cash. The motion to modify bail is denied. Counsel, is there anything further to address before our next hearing on the 19th? Attorney Buting. Not from our standpoint, Judge. Attorney Kraft. I don't think so, Judge. We'll see you on the 19th. Thank you. The court. Very well. We'll see you on the 19th. We're adjourned for today. Proceedings concluded.